Disability carriers, like Cigna, are not in the business of paying benefits for the maximum policy period, regardless of the nature of the disabling medical condition or the opinions of the policyholders' treating physicians. Theirs is a cruel business model: collect the gold but deny benefits. Let me tell you the case of Moore versus Cigna. It's an Eastern Michigan disability case, and I think this is a lesson on point. Ms. Moore was a flight attendant. She was paid disability benefits for 12 years as a result of lupus, when Cigna decided to terminate her benefits based on the opinions of their peer-review doctors who never examined her. Those peer-review doctors opined that she was neurologically stable based on a review of her medical records. Now, surveillance showed her doing regular activities, and that surveillance and the medical review led Cigna to conclude that she could do sedentary work. They denied the payment of further benefits. As a result, she appealed, and her appeal was upheld. But they had her file reviewed by physicians who didn't specialize in lupus. Yeah? Cigna's use of unqualified peer review providers created a tempest in the courthouse. The court reversed the denial on the basis that it was arbitrary and capricious because not one of the physicians was qualified to render an opinion about lupus. Cigna had to show something had changed about her lupus, that Cigna had new medical information about the nature or progression of her condition, or that her physicians had failed to fully respond to any requests for information, or that her physicians felt that she was capable of working. The court criticized the opinions of Dr. Cavey, who is a frequently used peer-reviewed doctor used to justify a claims denial. And I'm glad that the court took him on. Now, the court said the surveillance had no real relevance to working since it only depicted normal and not work-like activity. In my view, there's some lessons to be learned here. First, review the reason for the claim's termination and see if they pass the smell test. More often than not, they don't. So you want to consider taking an appeal of a denial. You want to consider appealing because of the improper use of surveillance in justifying a claims denial, when that surveillance does not show any activity that's inconsistent with activity of daily living forms filled out by you, or doesn't show you doing anything that's inconsistent with the restrictions and limitations assigned by your physician. Secondly, take a close look at that claims denial and see if it actually tracks what's happening medically in terms of exam findings, symptoms, functionality. Look at the claims denial letter and see if it discusses prescription medication or frequency of treatment. In other words, does the records ignore the fact that your symptoms are getting worse, that your medication has changed, that you're less responsive to the medication? And lastly, if you see that the carrier has used for a liar-for-hire peer-reviewed doctor, I think it's time for you to consider taking on the disability carrier. If your claim's been denied, call me today at 727-894-3188. I can help you take on a wrongful denial of your disability benefits. It doesn't matter where you live in the United States. I'm here for you. 727-894-3188.